Welcome to the first lecture of the Business and Human Rights series organized by the Open University. My name is Victoria Azizi, and together with Mark Kawakami, we will be discussing what it means to conduct business in a globalized world. In short, doing business in a globalized world seems to be a blessing and a curse for corporate actors, respectively multinationals. The seemingly irreversible trend, called globalization, a triggering combination of cross-border trade, the internet, creating global transparency and global connection, technology, has given essential ingredients for businesses to go easily beyond domestic markets to access resources and consumers. For example, a business headquartered in the Netherlands may have suppliers in Africa, a manufacturer in Asia, and have their products shipped and sold to consumers across the EU and beyond. However, in doing so, a corporation is not only expected to comply with laws and regulations of foreign jurisdictions, but also with other existing and upcoming global regulations. In the coming 30 minutes, we will present the background and the challenges of regulating business in a globalized world. Afterwards, we will provide an overview of existing regulatory measures, along with noticeable trends, challenges, and its effectiveness and ineffectiveness. Lastly, we will reflect the future outlook of doing business in a globalized world by discussing our personal takes on potential solutions. When explaining the way in which multinationals have conducted business, one can't overlook the various scandals that have evidenced human rights and environmental intrusions. The scandals revealed, for instance, the irresponsible ways multinationals have carried out business activities in developing countries. Examples: Nigeria, Ivory Coast, Bangladesh. And how they have abused the weak regulatory measures of these countries as a vehicle for their own growth. Also, with the involvement of civil society through, for example, NGOs, the aftermath of most of these scandals has not been limited to societal trust issues and damaging reputations, such as naming and shaming, but it has also kickstarted endless litigation battles. As a reminder to the question on how corporations can be involved in human rights intrusions, normally to conduct business, corporations have to team up with the local authorities. In other words, obtain a license for exploration or exploitation of natural resources, to buy or lease a land, build roads or ports, and eventually sell products. If local authorities do not protect human rights, for example, or rather infringe those rights, it is likely that a corporation collaborating with such authorities will be caught up in regrettable situations. Cases of corporate wrongdoings have, for example, demonstrated the governance also referred to as regulatory gap found in the business and human rights arena. This has to do with the transnational character of multinationals and the growing bargaining power multinationals have towards various kinds of regulations. Mark will outline these latter aspects more in detail.
So, as Victoria just hinted, it's no hyperbole to suggest that some multinational corporations have become as influential and powerful, if not even more so than some nation states. So for example, Apple's market cap at $2 trillion is bigger than the GDP of, say, Italy or Canada. Now, given this considerable resources that they've accumulated, it is tempting to demand that business actors spearhead initiatives to promote environmental protection, or work towards policing human rights violations in their supply chain through contract law and other private law or soft law-based measures. The CSR, the field of CSR, as a matter of fact, has been predicated upon these hopes that businesses can be catalysts for pro-social changes in the global economy. However, while there are indeed businesses intent on becoming forces of good, doing business in a globalized world not only means pro-social and sustainable commerce across borders, but as Victoria already mentioned, dealing with abundance of corporate malfeasance by the hands of businesses with the take everything and leave nothing behind mentality. So as a result, businesses must operate on a rather hazardous playing field where a handful of corporate titans wield incredible amounts of power that is not only dangerous from a competition perspective, but harmful in the sense that these multinationals challenge the legitimacy and the effectiveness of national, supranational, and international regulatory regimes. Now, this is to suggest that governments who were once considered to be the remedies to the tragedy of the commons problem today have apparently become a part of the tragedy in this globalized world. In the words of the economist Mariana Mazzucato, globalization, which triggered a frenzy of outsourcing and privatization, has damaged governments' abilities to regulate effectively. Now, this weakening of the government's regulatory power was, according to Mazzucato, perpetuated by the notion that private actors know better and that governments should take a back seat and only come in to fix problems when they arise. Now, this core ideology, panhandled by the likes of Thatcher or Reagan in the 1980s, have enabled the private sector to run amok, even to the extent of permitting some influential companies to manipulate where the boundaries of regulations ought to be through various lobbying measures and backroom deals. Now, but before we get too carried away, let us first highlight some of the basic problems and challenges related to business and human rights in a globalized world, along with existing measures that aim to address these challenges. Back to Victoria.
So while plenty of arguments can be made regarding the differentiation of business and human rights, CSR, corporate social responsibility and their regulation, our view is that the regulatory measures in both fields aim to incentivize responsible conduct for and by multinationals. For instance, the regulatory attempts ranging from transparency frameworks to stakeholder engagement and supply chain management are in essence established to tame multinationals' irresponsible conduct and to promote human rights, environmental and labor protection. Therefore, for the purpose of this lecture and also in explaining the existing measures, we will use business and human rights and CSR interchangeably. The governance triangle by Abbott and Snydell perfectly illustrates the multiplicity and range of transnational regulatory schemes in fostering responsible conduct. Although the triangle can be perceived as a bit outdated, since it's from 2009-2010, in my opinion it is still the best example in demonstrating how the traditional governance that was essentially state-centric, centralized with mandatory rules, seemed to have shifted to new governance that is decentralized with dispersed expertise and a soft law shield. As you can see in Zone 1, examples of state-led initiatives are OECD and ILO guidelines, which are considered to be legally binding for the member states, which are considered and are sovereign states. However, the triangle does not only display states as the regulatory participants, but also NGOs. This can be other activist groups and experts group, and this can be also firms or corporate actors, for example. These actors are able to cooperate with public authorities. They can create, for example, co-regulation or other hybrid forms of regulation such as private and public schemes that you can see in zones 4, 5 and 7, like the UN Global Compact. However, they also have the regulatory ability to create their own regulations, and such as also labeling schemes. This you can see as in like private schemes in zone 2, 3 and 6, and an example, a very interesting and important example, is the Max Havelaar Fair Trade Coffee, for example, as a labeling scheme. Considering the length of this lecture, I'm not able to explain from a micro perspective the implication and effectiveness of these regulations. That's left to be tackled in my doctoral thesis. However, from a macro perspective, these private and hybrid regulation are a controversial topic in academia regarding its effectiveness. Before I elaborate on that, Mark will first explain some noticeable trends and challenges in nourishing responsible conduct.
In addition to the various voluntary frameworks and soft law measures that exist in the domain of business and human rights, as noted by the triangle, there are two trends worthy of highlighting in this domain, which are 1, the popularity of legislations that aim to increase corporate transparency and to effectuate sunshine policies. Now, these are exemplified by the EU's non-financial disclosure directive, which requires companies to conduct due diligence on ESG metrics, California's Transparency in Supply Chains Act, French law on corporate duty of vigilance, UK's Modern Slavery Act, just to name a few, right? And the second trend worthy of mentioning is the crystallization of otherwise voluntary measures. For example, the UN Intergovernmental Working Group's Zero Draft that seeks to make the otherwise voluntary UNGP a legally binding international convention. Now, with respect to the second point, many CSR-based measures already attempt to couple voluntary or aspirational goals with binding force of private law. Think about codes of conduct, think about incorporating as a benefit corporation, and so on. Now, however, these lingering concerns about the effectiveness of these trends and whether they are truly capable of reducing or controlling third-party harm, negative externalities like pollution, and human rights that violate our fabric of our society that are taking place on the other side of the world. And when it comes to the ineffectiveness, the part of the problem with the existing measures, which Victoria will elaborate in more detail later, is that corporate stakeholders and other non-governmental organizations and personnel, private personnel, have become increasingly involved in the rulemaking process. Now, while this increase in democratic representation is not a problem in and of itself, when there are self-interested entities with self-perpetuating objectives, making rules, or influencing the legislative process against the interest of the collective, there is a huge incentive problem that negatively affects the lawmaking process and how the law is actually enforced. So, for example, where Dutch Shell's near symbiotic relationship with governments of the Netherlands and Nigeria have in the past been hinted as something concerning, if not sinister. But this problem is not limited to these rare and exceptional instances, as big oil companies, for example, like BP, Total, also Shell, have spent more than €250 million in the last decade lobbying EU policies, with an army of 200 plus lobbyists holding almost weekly meetings in Brussels. As it's colloquially noted, this is the fox guarding the henhouse problem. Now, this is also part of the reason why initiatives that attempt to crystallize soft law instruments, the second trend, for again the UN Intergovernmental Working Group's their draft on legally binding instruments to regulate in international human rights law the activities of transnational corporations and other business enterprises. It's a mouthful. But these initiatives are politically infeasible at the current juncture because the powerful business interests are preventing these measures from being actualized. Now, from a more content-based perspective, there's also a concern with regards to some of the more popular legislative measures like the aforementioned transparency legislations. Now, for example, the implicit assumption that transparency and sunshine policies will incentivize companies to behave in a more pro-social manner. Now, the idea behind it is simple and understandable enough. If companies are asked to publicly air out their dirty laundry, they will try to clean their sheets a bit better in private. Okay, simple enough. However, there are shareholders who do not care that the sheets have been soiled on, so as long as they are sources of profit, there is no problem for them. So there is a problem with the underlying assumption that shareholders will divest or that consumers will boycott companies with unsavory practices, at least at a level that will hit critical mass. So with the exception of a few handful of successful divestments or boycott cases, many private actors are seemingly succumbing to cognitive dissonance and often fail to act in a pro-social manner, regardless of how much information is out there. Now, this is to suggest that existing measures of this sort are only minor adjustments that still enable businesses as usual to continue without drastically fixing the problem that is much, much bigger. So, having addressed some of these very general problems and the emerging trends, Victoria will now take a more in-depth look into the emergence of the private and hybrid regulatory frameworks.
As hinted earlier, the urging element in both private and hybrid regulation is that corporate actors, such as multinationals, as non-state actors tend to behave more like political actors, create their own private regulations and/or increasingly intervene in the regulatory process of public law. Thus, the questions can be raised. First of all, how can the legislative ability of corporate actors be determined? Secondly, how can the effectiveness of these regulations be measured? An attempt to answer the first question is legitimacy and outlining that concept. It is similar to CSR and business and human rights because of its broad and indistinct characteristic approach from various fields. However, for the purpose of this lecture, an example of legitimacy is inserted. Legitimacy is the usual source to justify, perhaps also in moral terms, the wielding of any authority and legislative ability. Similar to governments, whose coercive capacity is reinforced by their legitimacy, corporate actors also require legitimacy to license their cooperation and intervention in policy development and enforcement measures. Yet, unlike sovereign states, by which definition possess legitimate authority, or intergovernmental organizations which derive their legitimacy from sovereign states, as they are their member states and their consent, corporate actors are suggested to actively seek legitimacy. There has been numerous demands in academia how to obtain legitimacy as a corporate actor. There is this increasing demand that is related to input legitimacy, that the development and implementation of private and hybrid regulation and their standards should be well represented, inclusive, absorb and refer to universal principles and norms. Secondly, related to throughput legitimacy, it should be transparent, include participation, deliberation of affected stakeholders, and also have a monitoring and responsibility system. An attempt to answer the second question is the degree of compliance. In other words, the higher the degree of compliance and acceptance, the more effective and again legitimate the regulatory framework is perceived. The idea to measure effectiveness is naturally the degree to which governance achieves its goal. Another way to look at effectiveness is to see how effective the norm is in changing the behavior of states and other non-state actors. These two dimensions are often referred to as either problem-solving or behavioral effectiveness. Consequently, I would like to introduce the last perspective. The output perspective, output legitimacy, refers to effectiveness of regulations in the way that it says the idea that rules will effectively solve problems because it holds people, for instance, accountable in case of non-compliance. So this area is very interesting because what is accountability and how can you determine it in global governance? That is the question that remains mostly undetermined and absent in many of these regulations. Many scholars have tried to replace this accountability concept by, for example, introducing and perhaps also this replacing idea of these examples of market pressure, naming and shaming, creating positive incentives, a system of reward, such as remuneration, and now also the increasingly intervention of courts. The upcoming lectures of business and human rights will grapple with manifestation of the core problem. For example, the next lecture will further elaborate on the emergence of corporations as powerful legal entities that have triggered the transformation of authority and legitimacy. We will also further outline how public interests have seemingly been displaced by business interests and the concerning lack of effective legal protection caused by the political sensitive and the legal infeasible extraterritorial enforcement measures.
So in talking about future outlooks, new solutions, the path forward, it's a little bit exaggerated, but alas. Now, given the overview of these existing measures and their problems, and linked with the core issue of governments having lost their abilities to govern and regulate effectively in the aftermath of globalization, the unpopular argument that I would like to throw back into the ring is that while private transnational regulation has, without a doubt, a role in improving human rights compliance or addressing other global problems, it is a complementary one to that of governments, who need to be empowered once again to do their jobs more effectively. Globalization, no doubt, has made this task more difficult, and the cure isn't solely in the realm of business and human rights, but in CSR's companionship with effective governments capable of providing competent regulatory measures, meaningful sanctions, and really inspiring a shared or common objectives to the private sector. So while increased corporate involvement can indeed be a positive development, and has been to some extent, I also believe that governments must also set up some firewalls against self-interested multinationals attempting to tempt governments into complying with their wishes. In other words, we need to empower and enable governments that will look after the interest of the collective and not just of the privileged few. What we need now, in the words of Matsukato, is a massive rethink of not only what government is for and the types of capability and capacity they need, but perhaps more importantly, what sort of capitalism we want to build and how to govern the relationships between public and private actors better. So with that, let's move on to our discussion. So we're speaking about discussions, and I would like to start off with a possible point of the fact that I don't necessarily agree with labeling governance as old or new as such, especially when old somehow connotes these hierarchical or centralized forms of government, as if to imply that the government was the problem. Of course, governments do have their shares of flaws and problems. I mean, who doesn't? But going back to Matsukato's point, how governments are portrayed as weak and ineffective in this global arena, I think is part of the problem. So we need to give them some resemblance of control or authority back so that they can regain or they can be re-legitimized. And simply giving the private actors more and more power, control, and the ability to make rules, I don't think is necessarily helping to address the problem. I think that's sort of how I feel on the issue.
Right. No, I understand your point of view, especially when you say that it should not be necessarily with regards to old or new whatsoever. However, perhaps I'm more a constructivist scholar, that I believe that the focus should indeed be less on the formal terms of law, such as the enactment stage, and more on law as a part of process of social interaction. And it should also be more that this social interaction can shape shared social understandings of appropriate behavior, especially in the field of CSR and business and human rights. So this whole characterization of law being hard and soft essentially, in my opinion, also fails to capture how law operates normatively as part of an interactual process over time. So essentially, the creations of these hybrid and private regulation should, in my opinion, serve more as a bridge to the accumulation and gradual transformative effect of shared norms and state practices over time. So in my perspective also, in order to be an effective government, there is a need for this regulatory creation by non-state actors. As it addresses these regulatory schemes, they address how society, behavior, norms and standards have changed due to all the mentioned elements of this lecture, not exclusively, and have shaped the traditional perspectives of law. So for example, what I mentioned before, what is undeniable is that these regulations have transformed and also lack the traditional elements of what I mentioned as accountability and legitimacy. So in this respect, if I would think about your empowering part, I would place the empowering part towards these regulations. In essence, there are these forms of self-regulatory frameworks in the field of CSR, business and human rights, in the form of code of conduct, and they should be taken more seriously rather than portrayed as a PR move or a public gimmick. And this is both from a multinational side as well as from a state actor's perspective. So when they have taken up this job of better policy making, then let them do the job of better policy making. So in essence, I also think that although I acknowledge this whole idea of piercing the corporate veil, that it's difficult, there are a lot of different thresholds, I still think that there is a possibility that these regulations should become, for example, internally and externally binding through corporate governance, in the hope to allow courts and other judicial actors to examine these regulations. And in case of non-compliance, play this deterrent figure. And I would hope, and my aim is then, that it would steer these non-state actors that have taken up this job of policy making into a better job and a better performance. And here we come actually to our second debate point.
Yeah, no, but I mean, before you do that, just real quick, I do agree. I like the idea of building bridges and this idea of shared norms. I think that makes sense. So I think you and I are not that different in that regard.
No.
The question is, how do we redraw that line? How do they share it better? And I think that's the core of the question, that the difficulty.
Yeah.
I think that we're trying to answer the same question.
In essence, what we do is we place the empowering part on various actors.
Yeah.
You do it more towards governmental actors,
Yeah.
should regain, relegitimize authority. And in my perspective, I think we should deal, we have already these existing measures, they are not there for nothing. Let's just empower them to do a better job.
Yeah.
And perhaps we would diminish this tension between them.
I know, and like I said, I think this might be an unpopular opinion. But yeah, I got it. Debate point two.
Debate point two,
Debate
yes.
point two.
So what are these important incentives for multinationals to abide by these CSR, business and human rights regulations, and promote human rights and labor protection and environmental protection? What do you think, Mark?
Well, for me, I think I'm fascinated by the field of sort of organizational psychology. And so in that field, they divide intrinsic and extrinsic incentives. And so the extrinsic incentive being doing something because you have to, and intrinsic incentives being you do something because you want to. I think government regulations are always presented as extrinsic, whether it's the carrot or the stick. But there are emerging findings, I think, from the field of behavioral sciences that can help us in answering this question of how do we better incentivize private actors. And part of the key is not to present government interventions as purely extrinsic. I think governments can sort of give intrinsic incentives as well. So, for example, I think the work of Katie Milkman and Angela Duckworth at Wharton's Behavior Change for Good initiative, I think they were doing a lot of great work sort of trying to figure out how do you foster intrinsic incentives? How do you create better, more pro-social organizations? And so this is sort of a very broad way of answering the question, which is to say, in order for us to better incentivize private actors, I think governments have to sort of build new tools to sort of foster intrinsic incentives better. And the broader takeaway for me would be, in order for us to do that, I think we need to embrace both private and public actors, the idea of interdisciplinarity, learning about not just policy making and understanding how laws are designed, but also learning about sort of this organizational psychology and different things that we might not usually consider as lawyers.
Yeah, I think I understand your point of view. It's a little bit of experimenting with other knowledges of different fields. And also from what I know, this idea of extrinsic incentives, like a system of rewards in case of good performance, like remuneration, has been extensively also used in the field of corporate governance. And there is an abundance written on the desirability and effectiveness of this idea. Many scholars question, do individuals perform better due to the fact that they receive an extra bonus, or because they really want to perform? And I think perhaps it is a good idea to maybe now look into the field of intrinsic motivation, especially for multinationals, and perhaps also in enhancing corporate citizenship. So you have many studies that would actually say investing in environments, in communities, in a workplace with a higher quality of living, and making employees, in essence, more involved in an organization, CSR processes and outcomes, would hopefully and possibly steer intrinsic motivation in better performance. It is suggested that mainly employees play a vital role in boosting the organization's identity and in reputation. This is because of the awareness of employees towards concepts of CSR and business and human rights that have been suggested to positively affect the sense of, for example, self-esteem, pride of the organization, a form of emotional commitment, perception of the corporate reputation, and also job satisfaction on the working behavior and the working environment. So I think that now, if you don't have further remarks.
Yeah, no, I mean, maybe just one quick one. I think a similar thing with public and private divide or the hybrid. I think the presence of both intrinsic and extrinsic incentives, I think, complicate and interact in different ways. So I think, I agree, more intrinsic incentives, paying attention to those things might actually produce better outcomes. The existence of intrinsic incentive together with extrinsic incentives kind of complicate the impact that they might have. And that's also another thing that I don't have answers to. But yeah, I mean, I think these are very interesting points.
No, but you cannot also measure and look into the minds of people. Do they do it for the money or they do it because to perform a better job? And obviously you can sense and think they do it for the money, but you don't know. So instead of complicated things, we should look and in other solutions. So with that said, I think we can go to the concluding remarks of this lecture. I think I would like to give you the floor for this.
Oh, we're doing concluding remarks. Yes, concluding remarks. Next slide, please. So yeah, I think in the end, I submit that Maxwell and Leon's prediction, I think, was indeed correct, right? Which is moving away from strict regulatory regimes to a softer type of more voluntary regulation did indeed facilitate a higher involvement of corporations, private actors in the field of CSR. Great. But higher corporate involvement hasn't necessarily translated into a very beneficial outcome for all the stakeholders, especially not for the victims of the corporate malfeasance that you were talking about in the beginning. I think this is because business's primary objective, their raison d'etre, don't mind the pronunciation, at the end of the day, isn't about protecting human rights. It's about perpetuation of their business, their continued existence. So the hope that I once possessed for private transnational regulation, CSR, BHR, whatever, other voluntary measures, to be perfectly honest, has somewhat diminished over the years for me. But I still firmly believe that there is a way for the public sector and the private sector to sort of collaborate together to overcome very difficult challenges. But in order to do so, I think we need three things. First one being the ability for us to operate with the increased awareness of our deepening interdependencies. One thing happening here impacting this on the other side of the world and so forth. Second point being that we need to acknowledge that existing measures are very incremental in nature. Again, that's how I feel. And as necessary as they might be, they will not effectively resolve the grand problems that we are facing today. And the third point, perhaps most controversially, I think we must empower the governments to get their acts together so that they can once again inspire and enable businesses to be more willing and constructive partners in addressing many of our daunting societal issues, which, again, I think is rotting the fabric of our shared existence, but I tend to be a little bit negative in that sense. Something more positive, perhaps.
Yeah, well, I mean, I hope, and we hope, actually, that this first lecture provides also for you as the viewer, but at least in our opinion, it provides a meaningful contribution to the analysis of doing business in a globalized world, the challenges regarding regulatory attempts from global institutions, non-state actors, and a foundation for future lectures to address these tensions in the field of business and human rights, respectively, CSR. So in my perspective, CSR and business and human rights agenda needs to be locally owned if it's going to make a significant contribution to local development priorities, as it must be relevant to local enterprises, whether it's just a small business or a larger multinational, for example. This means creating a space to explore the relationship between business and society at a regional, national and local level, and finding the appropriate language for these discussions. So as the entrepreneur Raymond Ackerman cites, doing good is good business. I don't know if you agree, but I think that perhaps he says something that could be truthful. At least his comment has been based on direct knowledge of developing regular, socially responsible programs within the organizational structures and within local communities and affected communities. So the only thing that we differ, last point of Mark, I take a different route to Rome. The empowering aspect should essentially be in the field of global governance. As I already mentioned, non-state actors have taken up the job to create regulations. They already have regulations in place, so they should be empowered to do a better policy-making job. Since they are now binding, non-legally binding, and therefore usually fend off as a public relations move, a PR move, if they could become more or less internally and externally binding, they could perhaps be a more effective and complementary regulation, and perhaps also with the use of courts and the intervention of courts, these accountability problems will be overcome. Thank you very much, Mark, for being here.
Yeah,
and also you for watching this video.
Yeah.
And yeah, thank you. And see you next lecture.